好，各位线上还有现场的来宾，大家好。那今天很欢迎各位参与这一次的研讨会，题目是2023年度大陆专利复审无效典型案件决定摘要回顾，以及2024年的美国最新专利实务发展。那今天呢，除了本所以外呢，我们很荣幸的邀请了 Davis 在美国很有名的事务所来这边，跟我们一起共同参与这个研讨会。那这一次的这个研讨会，主要包含了3个段落。第一个段落是会由我来主讲，是关于介绍2023年度由大陆的国家知识产权局他们精选出来的几个跟专利无效或者是复审有关的案例。那会是以中文的方式呈现。那关于第2个跟第3个部分呢，会是由 Davis 的那个 Adams 跟 Jack 来去向各位介绍。那Davis 这边他们也很贴心的在那个就是简报档那边附上了中文的这个翻译，所以你们在听讲解的时候呢，也是可以，如果有什么不懂的地方，也是可以看中文的部分来去做解说。那我相信这一次的这个 presentation 呢，对大家都会很有帮助，同时可以接受到关于中国大陆这边的专利实务，那也可以接受到美国的专利实务。那特别在美国实务这部分呢，我们牵涉到最近最热门的关于人工智慧，就是由人工智慧工具所发展出来的发明的一些法律议题。然后再接下来就是我们在亚洲国家，特别是台湾啦，还有日本、韩国等等这些常常会遇到的高科技公司遇到的这个所谓的专利蟑螂 （patent troll） 的问题。好，那在公司内部要怎么样去应对这样的这个专利蟑螂所主张的一些权利，我们来去在这一部分呢，我想就是 Jack 这边会有很详细的介绍。那接下来我就开始第一部分，关于2023年度大陆专利复审无效典型案件的这个摘要部分。在针对这一部分呢，大陆的国家知识产权局他们有选入了几个比较典型的案例。那我们也除了说，虽然说这个是关于专利无效的部分，但实际上我们也可以从专利无效的他这边的决定里面的内容呢，可以知道说最新的他们的审查实务。因为专利无效的这个关于专利有效性的审查呢，其实跟在专利申请时候的有效性包含的新颖性跟创造性的审查也是非常的相关。所以对各位在处理大陆案件的部分，除了无效的部分以外，在申请的过程当中也会有相当的帮助。那一开始我先稍微介绍一下本所的跟大陆这边业务的关系哈。本所在上海这边有一家绿盟知识产权代理有限责任公司，然后在上海的部分有绿盟的分所，然后它本身也有上海律同恒的法律事务所，所以本所基本上可以去为所有的客户服务，在大陆方面全方位的法律服务。那我们在台湾的申请案件每年大约有8500件，大陆的申请案件大约有2500件。那在大陆案件这边也有30余年的历史。那现在很简单的跟各位介绍这一部分。那这部分是接下来是我个人的一些资历的资料。那我本身有中国律师的资格，还有中国专利代理人的资格。他们现在把中国专利代理人叫中国专利代理师。所以现在名称稍微有点修改。那我本身也是台湾的专利师，然后也有美国纽约和马州的律师资格。那接下来我们就进入第一个案例。那今天刚好我们的美国的来宾也有讲很多关于人工智慧的部分，所以我们也不约而同了用了很多可能应该是 ChatGPT 产生出来的一些图案。也可以看到很多其实关于这个人工智慧他们产生的这个功能是非常强大的。那 那不过第一个案例是跟人工智慧是没有关系的。那为了节省各位的时间，可以在比较短的时间内，可以去审阅很多的案件。好，那我会用比较快一点的速度去用摘要型的方式。那大家可以看到，我会在这案例里面呢，用这个不同颜色的标示来标示这个重点。那大家都知道，就是说在使用新型的部分，在台湾叫新型了哈，它本身的标的是有一些限制的哈。那我们比较知道就是说，在大陆的使用新型方法是不能够取得保护的，但是在有一些情况之下，譬如说是它的标的是系统，那系统里面的每个元件呢，其实是看起来像是硬体。但是在每个硬体之间呢，它又有描述了一些之间的一些互动的关系哦。那在这个时候呢，这个案例在案号5W133467号这个案例，它里面有提到的话，就是说，如果说你的标的看起来像是并不是方法可能是产品或是系统，但是呢，如果你这个权利要求，边顺带讲一下，就是中国讲的权利要求，就相当于我们台湾这边讲的请求项，它里面如果说已经涉及到，就是在描述到各个元件之间的关系的时候，是跟电脑程式对各硬体的控制运行有关的时候，而且它这个新型的这个创作点反而是在于这个电脑程式的这个彼此运行的部分的话，同时他这边讲就是说，同时没有证据证明上述控制运行属于已知的方法，就是习知，而也就是说，当这个使用新型权利要求所保护的发明，实际上是针对这个方法它的这个来去做保护的话或者是电脑程式来改的保护，它就不会是属于实用新型保护的课题。那第二个案例这边呢，我们来看一下它是关于网络真实性的认定的部分。那大家可能长久以来对这个大陆这边特别针对网络证据的部分，都一般有耳闻说都需要经过公证他们才会去承认。那在这个案例里面呢，他做了一个不一样的这个认定就是说他们认为就是说公证是一种保全证据的方式但是不是一个必要的条件，也就是说不是一定一定要有公证的这个网络证据才会被认定但是如果说这个网络的证据里面呢，它里面如果掺着了这个综合了商业习惯、当事人的举证能力，还有证据能力之间能够相互印证，我们这边叫相互勾稽啦如果说可以去从这样的经验法则判断出这个网络的证据是真实的话，而且在对方未能提供相反的证据推翻这个结论的情况下，那在无效的案件当中，通常就是对方就是专利权人的部分，他没有办法提供反证的话，那这样的网络证据还是可以作为证据作为现有技术使用那我这边也顺便提一下就现有技术就是在台湾这边就是先前技术的意思。然后另外一个点就是，当你们看到在中国这个无效知识产权局里面的暗号的开始的英文字母是 W 的它就是一个无效的案例。好，那如果是其他字母的话，那可能就是复审的案例，这边也提供过给各位听众作为参考。那在接下来这个案例里面呢，是关于优先权的部分。我们都知道每一个专利申请案呢，它可能会有多个优先权。那它会这些对比文件，也就是这些我们这边叫先前技术啦，或者是引证案，它有没有办法构成这个抵触申请的审查？那这边顺便也再稍微提一下，就是抵触申请这个名词是中国大陆这边使用的那我们这边一般讲就是明智先行性的 那在主张这个多项优先权的情况之下，这样的对比文件能不能构成抵触申请？不需要说所有的对比文件它的这个优先权的都受到认定以后才能够作为抵触申请，而是以特别是当这个案例当中，当对比文件的优先权日早于涉案专利的优先权申请日，而且申请日不早于涉案专利申请日的时候，这个时候呢是要针对每一个要跟这个请求项的这个所记载的发明的优先权基础案，它的是不是有效来作为判定呢？因为这个讲起来有点复杂，我们来看一下下一个图。好，举例来说，第一个呢，这个是权利要求所载的发明。好，那申请日呢？申请日在这里。好，然后我们可以看到他主张2个优先权。第一个优先权案的申请日是在要被无效的这个案件的申请日之后，它的优先权日在申请日之前。那第二个优先权案2也是这样的情况。那现在变成是说，在那个案件当中，他们可能争议就是说，是不是如果这2个案子的优先权日是不是都要成立才能够去作为这个就是对比文件，它是不是可以作为合格的这个无效的这个证据？那在这个案例当中，就是说，当你这个权利要求它记载的是 A， 那只要是跟 A 有关的这个优先权案，它是可以成立的话，就可以了哈。那优先权案的1的部分，它揭露的公开的内容是方案 A， 所以有真正相关的部分呢，是在这个权利要求案1的部分。那至于权利要求2的部分就不需要考虑了。这个案件的争议就在这里，也就是说，你必须以这个权利要求，也就是请求项里面记载的内容作为判断的基础。那来判断说是不是这个优先权案必须要成立才可以构成所谓的就是冲突申请，或者是说我们这边叫凝滞新颖性的证据。那我们大家都知道，就是说要作为一个可以无效专利的这个证据，它的effective filing day 或者叫做优先权日或申请日必须早于涉案专利的申请日之前，而且公开日是必须在这个申请日之后。所以像这个案例当中，这个由于申请日是引证案的申请日，它的优先权的申请日是在这个涉案专利的申请日之后，所以优先权日就会变得比较重要。这个案件当中，我们就知道说，必须是只需要考虑跟这个请求项所载发明有关的这个优先权，是不是能不能构成立即可，而不需考虑所有的这个优先权案。那在这下来这个案例呢，它是关于新颖性单独比对原则的原理了。这边提到的是，他这边讲到说，单独比对原则不应狭隘的解释为单个技术方案在形式上必须记载于现有证据的同一个权利要求、同一段落或同一实施例。也就是说，这边也就是说，在这个我们这边讲一下好，这个也是有一些用语可能跟大家，如果说没有常处理大陆案件的同事，可能或者是同号，或是贵宾啊，就是在中国这边，他们当讲技术方案的时候，你们用实施力 embodiment 这个方式，这个去思考的话就可以了哈。它也就是说，是不是需要就是说一定要同一个段落里面的一个实施力，揭露了所有的技术特征，才有这个可以去无效那个涉案专利的请求项所载的发明。他这边讲的是不一定要这么严格了哈，他就是说当某一个当这个对比文件里面的某一个实施力，它里面在描述这个实施力里面的时候，其实是可以看得出来，它虽然说没有去直接的去引述其他实施力的技术内容，但是如果说可以从它的里面的描述文字，可以知道说那个实施力其实也存在一些其他的这个跟其他实施力存在一些关联性，那也是可以把它视为同一个实施力。这样的话并不违反单独比对原则。也就是说，因为新颖性必须是一个单一的实施力 去公开了单一的请求项所记载的发明。但是它这个要求并不是这么严格的，说一定要形式上在那个说明对比文件的说明书里面的单一实施例，或是单一请求项去涵盖所有的权利要求所记载的技术特征。如果说是可以推演出来的话，也是可以的。那接下来这个案例呢，我想因为这个就是我们会走的稍微快一点所以如果大家有时间的话，各位贵宾也可以稍微看一下这里面的文字那我稍微解一下，在暗号后面的部分就是这件专利要被无效专利的发明名称那我先大概跟各位分享一下，就现在在大陆的这个无效案件，你们现在是他们不提供全文的下载，他们的决定他们只能目前为止我们的资讯是只能在线上去他们的官方的网页它只能让你看但是不让你下载全文所以我们本来也是希望说可以把这个决定的内容全部都把它下载下来，这样去做解说比较方便。但是因为由于中国这边官方他们的在资料库这边的做一些限制，所以虽然说我们都也看过这些案例的决定但是比较要把里面的内容引用出来是有点困难，这边也请各位贵宾有所谅解。那这边讲的就是说，在这个案例当中呢，它里面是一个方法的权利要求，但是这个案例当中就是说，它的这个方法权利要求里面包含了很多个步骤，但是在这个案子当中，它的步骤的这个方式其实就是先后顺序呢，是对它这个发明是有产生一些技术效果的而且在它请求项记载的这个内容里面，是可以隐含的推断出来说各个它的步骤的这个先后顺序所以在这样的情况之下因为它的这个顺序对它的创造性是有影响的，而且它在那个权利要求当中的技术特征也就是它的步骤呢，也隐含了这个顺序的时候，那你要无效这样的请求项或者是权利要求，必须这个对比文件，或者是说我们这个叫先前技术呢，也要公开这样的顺序，才能够去无效掉这个权利要求所记载的发明。那再来就是这个案例是提到的是所谓的反向教室英文叫 teach away。好，那我们在答辩的时候，常常就是说，如果是专利权人会说，哎，他这个两个引证案之间呢，或者是两个青年技术和现有技术呢，它们之间存在了这个反向教室，所以呢没有办法做结合，本领域的技术人员没有动机去做这样的结合那在这个案例当中呢，这个是关于这个就是资料传输的部分他这边的案例的结论就是说，是不是有这个反向教室？因为反向教室是对这个创造性，也就是我们这边进步性的肯定嘛那这部分呢，他说应该避免跟随提案者的角度仅依据局部个别的表述就认为现有技术给了正向或反向的技术教导。那这边他提到的就是说，应该是要站在本领域技术人员普遍实际的需求，然后来去确定它里面内容是不是真的有这样所谓的反向教室那这边提案者的角度就是，当然就是在这个无效的案件里面，就是无效请求人他的这个角度，他可能会引用了某一个段落某一句话来去支持他认为说这个对比文件里面，他提供了一些反向教室那在他们的就是中国国家资产监局，他们这边在处理无效案件的时候，他会依照整个说明书的内容去判断是不是真的有这样的反向教室。那再来就是说 仅记载部分关联技术特征权利要求的技术效果认定。那因为这个部分可能跟像台湾还有中国这边会在判断创造性或进步性的时候，我们特别在处理这些审查意见的时候，常常会有一些要求，就是说，当你没有办法证明它有一些技术效果的时候，通常会比较容易被认定是公司常识，就 common knowledge。那这个时候呢，如果你可以提出说某个特征它可以提供一些技术效果的时候呢，就可以有时候是比较容易去说服审查委员说它不是一个公司常识。那他这边有提到，就是说这个技术效果呢，必须是要这些记载在权利要求里面的特征都要存在的时候，才能够达到技术效果，你才能够用这样的技术效果的论点来去反驳对方，就是无效请求人的主张。如果那个技术效果呢，从说明书看起来，在像这个案例里面当中呢，当然就是专利权人主张说他的请求项所载的发明，或者是权利要求所载的发明有一些技术效果，但在说明书里面看到的那些技术效果，必须是譬如说是要 A 加 B 加 C 加 D 这4个特征都在，才会有个技术效果 Z。但是那个权利要求呢，只记载了 A 加 B 加 C， 而且如果说这个领域的人知道说，如果没有加上 D 的话，是达不到这个技术效果的。这个时候如果专利权人他以这个请求项可以达到这个技术效果 Z，这个来作为一个具有创造性的支持的话，在中国国家知识产权局这边他是不会认可的。所以在前面几个案例我们都可以看得出来，其实在中国大陆这边他们也非常的重视，就是判断的这个标的必须是严格的以专利里面所记载的权利要求的所记载的发明作为判断的这个依据了。那另外一种情况就是包含参数特征的技术方案是否公开的判断。那我们这边再稍微提醒大家一下，所谓的技术方案，大家就可以看到就是一个，譬如说是一个请求项所载的发明，或者是一个说明书里面记载的实施例，这样是一个所谓的技术方案，跟技术内容可能有点区别，然后技术内容可能是就是比较散落在各地的，但是技术方案的话，必须是一个完整的一个技术的方案，它必须能够解决一些技术问题的必须是一个比较完整的技术内容。他这边提到就是说，在这个决定里面，他提到说，对于技术效果可预测性较低的技术领域了这个时候如果说他的权利要求里面记载某一个公式譬如说我下面这边所引用当然这个公式并不是这个案件里面的公式啦，我只是举例而已。那像这样子的公式，如果说这个公式并不是说是比较高的技术领域，而且它还有一些很多条件才能够去得到这样的公式，这个时候它就是在中国这个官方在审查的时候呢，他会对你这样的这个公式是不是真的能够达到可以据以实施他们是比较抱持怀疑的态度的这个时候像这样的情况之下的话，说明书必须要记载相应的实验资料去加以佐证，因为否则的话呢，他们会认为你的公开就是不充分那 disclosure is insufficient 因为你只是提供了公式，但是没有充分的这个数据去做支持的话。那我这边也稍微跟大家提一下就是在中国的实务上面，他们对于这个就是是不是揭露够充分，然后还有修改是不是有支持的部分是相当严格的相当于台湾这边的要求是相当严格的那据了解是跟欧洲这边的实务是比较接近的。那台湾这边的专利实务，就我个人的了解是比较跟 美国跟日本这边是比较接近，那大陆这边的话，他们是跟欧洲这边的实务是比较接近的。如果大家有这样的一个概念的话，会比较容易了解。那再来就是关于人工智慧技术领域专利充分公开的审查啊。那我们也知道，就是说现在人工智慧 AI 是非常热门的哈。那就如我刚刚所说的哈，就是说他们现在中国大陆这边呢，关于这类比较类似就是人工智慧啦，或者一些新兴科技的部分，他们会对于你说是不是真的可以达到你讲这个技术效果，他们是会先抱持着存疑的态度。好，那你必须要提供充分的揭露内容，他才认为说确实是可以达到这样的效果啊。也就是说，你应该在当你涉及的这个所请求的这个权利要求所记载的发明呢，是跟人工智慧有关的时候呢，应该要在说明书中限定明确的资料含义，包含输入资料、输出资料的类型、属性、内容以及你是如何获取，并应说明采取的具体模型啊，如模型并非本领域已知的模型，还要记载对该模型你是怎么进行训练和优化的哈，可以使得本领域技术人员说明书的教导可以实现其所保护的人工智慧解决方案。那我们来看一看啊，就是说当授权阶段的修改这个案例是关于就是请求项解释了哈，我们的解释申请专利范围啊，他这边有提到就是说，其实如果讲的可能就是讲说禁止反悔原则哈，也就是我们的禁反言原则是适用的哈，就是说当你在取得专利的过程当中，当你为了要取得专利，好，然后你对这个权利要求呢里面的一些特征做了一些限定，然后去跟那个先前技术好去做区隔。这个时候你在后面他讲的确前阶段，这边我也稍微再解释，因为名词上可能会有一些差异哈。他们这边就是说授权阶段，就是说在取得专利之前叫授权阶段。那确前阶段可能就像在无效的过程当中，当你已经拿到专利权以后，要确定你这个专利权是否有效，叫确前阶段啊，就是当你在申请的过程当中，你为了要取得专利，你对里面的技术特征在自己做了一些解释哈，而且这个目的是为了要取得专利。当你在无效这个过程当中的时候，你就没有办法再去把它去扩大，再去做一些比较扩大的解释哈。好，那我只要讲就是说，就是禁反言这个精神是适用在这个案例里面的。可能在座的各位，如果是在专利行业有从事这专利行业的同事，应该是都可以很容易的了解。那再来我们讲到这个，就是简单来讲的话，就是请求项差异化原则了哈。那虽然在中国大陆这边他们是没有这个名词，目前为止我是还没有看到具体的这样的名称，但是这个案例其实它讲的就是请求项差异化原则。就是当你在包含了独立项与这个独立权利要求跟从属权利要求都存在的时候呢，应该是把它解释成包含了不同的范围啊，也就是说他这边提到就是说不应该将仅记载在从属权利要求从属权利要求就是我们这边讲的附属项哈。从属权利要求的技术特征解读到独立权利要求当中，以至于对独立权利要求保护范围造成不合理的限制就是说应该是独立权利要求你在解释的时候，应该是涵盖了附属权利要求的还有其他的部分，这样才对，而不是仅限于这个从属权利要求或者是附属权利要求它所记载的内容。那简单的讲就是请求项差异化原则哈。那如果大家对这个有想要更进一步了解，你们可以去 Google 一下，打请求项差异化原则，就可以知道它的含义在里面。那在接下来这个也是跟台湾跟中国的专利实务比较有关哈，就是有时候你专利权要有效之外呢，除了新颖性创造之新颖之外呢，我们还有一个就是必须要具有必要的技术特征。那所谓必要技术特征，就是它是实现那个技术效果所不能或缺的这个特征啊。 那这边有提到，就是说它其实是采一个比较广的方式了哈。那当你这个权利要求所记载的发明能够解决到说明书中提到的某一个技术问题的话，就已经满足了哈，不需要解决所有说明书里面提到的技术问题。那再接下来是关于分案申请修改超范围的部分哈。那这边他有提到，就是说分案修改超范围的标准，其实是跟修正是比较类似的，好，就是说你这个分案的这个内容呢，是不是可以从原始申请直接毫无歧义的确定？但是他这边也提到，就是说不是跟那个是不是支持是两回事情，也就是说，在分案的这个要求，它是比较严格的，我们就可以知道说，直接毫无歧义的确定，它要求是比是否可以得到支持要来的严格的很多。哦，那所以他就是说，这个判断的标准呢是以是否可以直接毫无歧义的从原申请的内容呢来得到确定。而它的标准并不是权利要求是不是可以得到说明书支持来作为判断，好，所以这边做了一个区隔。那简单的来说，就是说，我们可以说这边分案就是分割案了哈。分割案的这个修改是不是超犯，它的标准是跟原专利申请里面的修改是不是可以得到支持是类似的，就是是否可以直接毫无歧义的确定，哦。那它的范围是比权利要求是不是可以得到说明书支持要来的严格。那再来接下来这个案例呢，它是关于这个外文证据译文的部分哈，因为我们可以知道，在我们提出专利无效请求的这个过程当中，有些证据会是外文的证据。那依据中国专利实务的要求，必须当这个无效请求人必须针对这个无效的证据的全文或至少是相关的部分提供中译文但一旦提供中译文了以后呢，这个在审查的过程当中呢，它就会是以中译文作为标准。所以当事人主张使用外文证据的附图跟涉案专利进行比对，他提供的中英文并不是针对附图的译文，也就是说他在翻译的时候翻译错了，而且译文中涉及的技术特征跟附图中的相应标记也没有对应，然后即使就不考虑文字翻译的部分，从那个图案也没有办法直接毫无歧义的确定的话，那这样的如果说是没有办法去进到这样的这个揭露的证据的部分的时候呢，这个损失呢必须由这个提案人无效提案人自己去承担。那我们再看一下复审程序中依职权审查的部分就是说当这个在复审的过程当中复审这边它是可以有依职权针对如果说是他们发现有公开不充分的时候，导致合议组无法对驳回决定的创造性进行审查的话，他还是会去主动的去针对这个是否公开充分的部分进行审查，即使在原始的这个就是驳回决定里面并没有提到这个公开不充分的部分。那在这个案例当中里面有提到，就是说这是关于设计专利的部分它在中国这边的图的要求，特别是针对设计专利图示要求，它要求是比较严格的它对于主专关系唯一的产品呢，是可以只递交这个组装后的设计产品的外观的6面视图就可以满足这样的要求。但是针对具有不同使用状态的外观设计申请案的时候呢，就是应该要提交各种组合状态的可能的变化的视图否则后面的这个保护范围在解释的时候可能会对申请人不利。那我们可以看一下，就是下面这个案例，这个案例里面可以看得出来，就是说这左边是组合状态，因为它组合状态是唯一的那我们就可以不需要针对每一个案件、每一个元件，这个组件1、组件2、组件3去提供它的6面视图，我们可以只针对它已经组装完成以后的部分呢，来去提供6面视图即可 但是针对这个组装关系不唯一的产品，以这个案例来讲的话，也就是说像这个水龙头它的按钮的摆设呢，由于是3个元件，而且它的这个安装的位置并不是固定的。这个时候我们就在中国国家知识产权局这边，它会要求要你提供组件1、组件2跟组件3的每一个元件的6面视图。好，所以在针对这种组装关系是不是唯一的时候，在视图的要求也会有所不同。那我们再看一看哈，这个针对外观设计是否明显存在转用歧视的这个判断，这个案例里面呢，这个是它针对就是一个玩具的这个外观呐哈。那这边在这个案例当中，无效请求人呢，他是利用了另外一个外观，它标的是空气净化器的外观啊。它这个空气净化器的外观呢，跟这件外观设计专利里面的玩具泡泡机呢的外观长得是有一些地方是类似的哈。所以它以这个空气净化器的外观，它就是说可以本领域的技术人员可以把这个空气净化器的外观转用到玩具泡泡机哈，所以它不具这个有效性哈，可能是新颖性或者是创造性。但是在合议组他们在审查这个案例的时候，他认为说是不是可以转用呢？还是需要考虑到这个就是无效证据它的功能跟这个涉案专利的外观设计专利的功能是否具有一些关联性哈？那在这个案件当中，很显然就是说，他们认为说，因为空气净化器的用途跟玩具泡泡机的用途是有明显的差异的，所以这个本领域的人是否会有这个动机去把一个空气净化机的它的外观去转用到玩具泡泡机，他们是并没有得到合议组这边的认可。那再来就是在中国大陆这边，也就是有一个无效的理由，就是说，当你这个外观设计跟在先的权利、其他的知识产权产生一些冲突的时候，也是可以作为无效的理由。好，也就是说，如果你这个外观设计专利呢，也就是相当于台湾的设计专利，好，如果里面的这个外观设计的这个权利跟在先存在的权利，哈，最常比较遇到的这种在先的权利，包含了商标权跟著作权的部分。哦，那在这个案例当中呢，他们认为就是说，第一个，首先就是说，涉案的这个争议的设计跟在先的商标图形，并不是构成近似哈。那在考虑到专利权人在使用这个外观设计产品的意图、方式、行业习惯等等，他们认为说并不会去跟在先的这个商标权产生冲突。好，但是在另外一个案件里面，我们可以看到就是说他们的认定就是有不同的认定哈。可以看到在这个6W14858这个案例里面，这个标的左下方这个图是外观设计专利的照片，它是个运动鞋。那右下方这部分是其他人注册的一个商标，那这个在这个案件当中，这个无效的这个部门的合议组，他就认为说，这是会构成一些混淆的那会损害商标权人的权利所以他认为就是说，这样的话，这样的设计专利是无效的所以他判断的标准就是会综合去判断说你在使用这个设计专利的时候的呈现的方式的目的是不是会造成混淆，来做一个判断的基准。好，那这一部分我们就报告到这边完毕。那我想接下来呢，就是会由那个Adam 这边来继续替我们做介绍。那我们欢迎 Adam， 谢谢。
Hello, everyone. My name is Scott Adams. I'm here to tell you about protecting intellectual property in the age of AI, and specifically when you are using AI to develop new technologies and new works. I'm a partner at Davis Wright Tremaine. It's an American law firm with about 700 attorneys around the whole country. My particular focus is on patent portfolio development and related areas such as mergers and acquisitions, licensing, and other areas that involve IP. And I focus a lot of my practice on cloud computing, information security, blockchain, fintech, medical devices, and more recently, and actually I need to update this slide, AI, and a lot of AI and the processors and the computers that actually make the AI go. So real quickly, what I want to talk about today is, why is this a topic we care about? Why do your clients care about what I have to say today? Then we're going to talk about using AI in inventorship and approaches to AI inventorship, and then protecting innovations when AI is involved. And then we're going to talk about maybe some other ways of protecting innovations that are made using AI, which may be better in some circumstances. So real quickly, I want to discuss, what we are talking about here and to contrast that with what we're not talking about. And specifically what we are talking about is two things: AI-assisted inventions and creative works. So this is when a person, a human, uses AI in order to create something new, whether it's an invention or whether it's artistic, such as a video or a picture or a song. And we're also talking about when AI does everything itself. So AI invents something. AI creates the artistic picture, or movie, or song. But what we're not talking about today is the AI models or algorithms themselves and AI-based inventions. So like patenting the AI itself, that is a completely different topic that we're going to avoid today just for the sake of talking about this particular important topic. So why is this important? And the reason is, and that there are actually two reasons. One is when you have AI involved in innovation or creating artistic works, depending on how it is done, you may be unable to protect what the AI has generated. And that can be very important in a company that relies on protecting its innovations in order to gain an advantage in the marketplace. And even when you can protect it, another thing that can happen is that the IP that is developed using on the innovations that were made using AI can be difficult to enforce. And the reason is that when there are questions about whether you can protect an innovation or not, it decreases your leverage in litigation, and it extends the litigation, makes it more costly, and can ultimately have bad consequences for our clients. So right now, I want to talk about a case that was in the US, and actually this case is actually happening in other places around the world. But there's an inventor named Stephen Thaler, and he created an AI system, some software that he called Davis, that could generate patentable inventions, and it could generate these inventions all by itself. All Stephen Thaler needed to do was to press a button and say, invent something, and it did. On the right here, you can see this is a shape of a food container that was the invention of this AI. It's actually a pretty silly invention because nobody would actually want to buy this this container. But Thaler tried to get a patent on this for the purpose of seeing whether it can protect inventions that are made by AI. And not surprisingly, the patent office said, no, you cannot do that. AI cannot be an inventor, and we cannot grant a patent when the inventor is AI. Thaler appealed this decision to the higher courts, and the courts agreed that you cannot protect this innovation. Now, what does this mean in a practical sense? Well, it means that if you in your company are doing something similar, you might not be able to protect it. So while Stephen Thaler had a silly example that he was using in order to push the issue through the courts, you can imagine that this can happen in a real company making real innovations and using AI in its operations. AI, for example, can help improve creative thinking. AI can process large amounts of data, recognize patterns in data, and generally process information in a way that humans cannot. AI can also test or verify inventions. AI can also identify problems and actually solve those problems. And all of these things that AI can be used to do can be used to create inventions and works of artistic works that traditionally we have had no problem protecting. So real quickly, we want to talk about how different countries around the world approach this. And not surprisingly, this is a pretty new issue and there's not a lot of information, but we are starting to see some things coming to light. You can see up here that some major jurisdictions, such as China, Japan, Taiwan, the US, and Australia, do not allow AI to be an inventor. The United Kingdom and New Zealand take a slightly different approach, where you can have AI as an inventor, but only if a human inventor is also on the patent. So this means that an invention was made by both a human and AI. The European Patent Office takes a similar approach, where you can list AI as an inventor if there's also a human inventor. And the owner of an AI inventing machine might be able to be listed as the inventor. So in Thaler's case, possibly Thaler could be listed as an inventor because his machine is the one that innovated. Now, South Africa, interestingly, allows AI to be an inventor. So presumably, Stephen Thaler's drink container or food container might be patentable in South Africa. Now, this will raise some interesting issues that we'll talk about in a little bit. Here is a breakdown of the European Patent Office approach to AI. They have three categories, two of which allow protection via patent, but the last one they do not. So the European Patent Office allows inventions where the human uses AI for outcome verification. So the human invents something and the AI is used to verify that this works, this will do what it's supposed to do, it won't have problems, or if it does have problems, those problems are minor. Also, the European Patent Office allows protection when a human identifies a problem and uses AI to find a solution. But it does not allow patenting when AI identifies a problem and proposes the solution without any human involvement. So to summarize the EPO's approach, the more a human is involved, the more likely you are able to protect it. The USPTO, the United States Patent Office, also has a similar approach. And the U.S. Patent Office takes an approach that focuses on what the human does in the process of the innovation. And to summarize their position, the Patent Office says that activities by a human that would ordinarily qualify as conception of the invention will continue to meet the requirements for patentability. Now, the Patent Office says that there is required a significant human contribution. Now, you may ask, what does that mean? And my answer will be, I don't know. This is new. But there are some cases that do not relate to AI that we can look at and get some hints at how we think this might develop in the future. And an interesting thing in US patent law over here on the right is that the Patent Office takes a position that you must disclose the use of AI in a patent application. Now, this may surprise a lot of patent attorneys outside the US. And the reason is, in the United States, attorneys and inventors and anyone substantively involved in the patent application is required to, has a duty to present to the Patent Office information that may affect patentability. So this usually comes up in prior art. If you file a patent application and then become aware of prior art that may make your invention not patentable, you are required to disclose this information to the Patent Office. And the consequences of not doing this can be that your patent is not enforceable, even if it is ultimately patentable. And for the attorneys, you could lose your license. So this is important. Now, I mentioned that the Patent Office requires a significant human contribution, and don't really know what that means because this hasn't gone through the courts yet, but we can look at some previous cases to get an idea. One thing is that a person, in order to be an inventor on a patent application, and therefore on a patent application where the innovation was made with AI, needs to contribute in a significant manner to the conception or reduction to practice of the invention. So the human must somehow conceive of what the invention is going to be, maybe not completely, but a significant amount. And also, the human must also be involved in the reduction of practice, so finding the solution to the problem and providing enough detail that one could actually make the invention. The actual contribution is measured against the full invention. So if what this means is that if the invention is very significant and the human played a very minor role in that, there's a good chance it won't be patentable. And inventors must do more than merely explain the well-known concepts in the current state of the art. Right? The human must do more than just providing information to the AI for the AI inventing. So let me give you an example, and this kind of brings it to the real world on where this might become an issue. So AI, as we mentioned, can analyze millions and millions, probably billions, sometimes trillions maybe, of molecular structures and predict which combinations are more likely to lead to an effective new drug. Now, what could go wrong with that? Depending on the amount of human involvement in that process, a company that uses AI to discover new drugs may or may not be able to patent the new drug. Now, for a pharmaceutical company, having a patent is hugely important. You know, a patent or no patent can mean success or failure of the company. Here's another example. You give an AI model the design of an engine and ask it to redesign the engine to make it less prone to overheating. And you know, this can happen in a lot of different contexts. Well, the same issue applies here. Depending on how much the human was involved in that process, the new engine or the new developments or whatever is making the engine better may or may not be patentable. Now, stepping away from patents for a second, this is another practical thing that we need to keep in mind because AI can be used to generate videos, pictures, songs, artistic works, and depending on the amount of human involvement, you may risk not getting IP protection for those materials. That could have a lot of problems for a business if, for example, other companies in similar spaces are able to use the materials without consequences. So we're going to discuss now, well, what do we do? How do we protect these? So some practical advice here is to, early in the process, research the patent law for each jurisdiction and know how to approach inventing in order for the inventions to be patentable. And the same thing applies to artistic works. If you know ahead of time, then you are much more likely to be able to protect what you are doing. It's also a very good idea to train inventors in order to encourage them to be more involved in the inventive and the creative process so that the outcome of that is patentable. It can also be helpful to document the innovation process. So, for example, if you have a significant human contribution in the development of a new product or a new work, you can prove that you had that and are able to protect it. Now, in the case that you do have AI inventor and no human inventor, maybe you just seek protection in those jurisdictions where you can and try to do your best in other jurisdictions. To be honest, that is probably not the best idea because, as you saw, most of the major jurisdictions don't allow you to protect only AI as the inventor. So how do we actually do this? How do we train the inventors? What do we tell them? Well, let's look at the same example. This is AI analyzing millions of molecular structures to predict effective new drugs. How do we protect our innovation? Well, in our patent application, we want to disclose the use of AI. You may be familiar with information disclosure statements if you work with US attorneys. This is the mechanism for doing that. Want employees to document how the AI is used, again, so you can demonstrate that you had that significant human contribution. And you want to document additional testing and verification. Now, doing these things will help you ensure that a new drug coming out of this process will be patentable. And to continue kind of along the same lines, if we return to the example of the engine, so this is AI redesigning an engine to make it overheat less. What can a human do? Well, during inventing, the human can provide specific constraints to the AI. So instead of just providing the engine and saying, make it overheat less, maybe the human will provide specific details on how to do that or what solutions to avoid and maybe guide the AI towards the solution. Because maybe there's additional information that the AI should take into account in order to provide the best solution among many. And if the human can be involved in providing that, then the outcome is more likely to be patentable. And then also it's important maybe for the human to iterate with a series of prompts. So the human will provide the problem to the AI, get a solution, review the solution, and then ask the AI and give the AI guidance in order to produce a better solution. Now, this can be done over and over again until the best solution is done. And then in that case, the human is involved in the whole process and an inventor. With artistic works, such as marketing materials, it's very similar. You want the human involved in the process, giving constraints to the AI, refining the output of the AI, iterating with the AI, and generally becoming a joint author with the AI. And again, it's good to document because you can then demonstrate the human's contribution. Now, sometimes you may not be able to patent your invention or copyright your invention, but there are possibly other avenues for protection. So for a patent, as you know, one way to protect your innovation is through trade secrets. Now, sometimes maybe if you can't get a patent on an innovation, you can have human involvement in the artistic aspects of a product that is innovated, that is created using AI in order to protect your product, maybe with copyright if there's an artistic aspect to that product. To protect as a trade secret, it's not that difficult actually. To qualify as a trade secret, the innovation must have economic value, and pretty much all trade secrets have economic value because otherwise you wouldn't be trying to protect it. Trade secrets need to be known by a limited group of people, have to be secret, can't be a trade secret without being secret, and be subject to reasonable steps taken to protect the information, to keep the information secret. Now, this may be, this may include keeping the information in servers that not everyone can access, certainly not publicly accessible servers. Maybe in your company you have security gates and only authorized people under NDA, if they're not in the company, can come in. Take those types of measures. Now, trade secrets are great because you don't have to disclose anything to the government. They last forever. As long as it's a secret, they're protected. You don't have to pay registration fees to the government. And you don't have to worry about the uncertainty of patentability. Now, on the other hand, depending on the innovation, your innovation may be able to be reverse engineered. If the innovation is a device that is sold to the general public, there's not a lot that would prevent a company from reverse engineering and making their own very similar product that operates in the same way. On the other hand, if your innovation is sitting in a server in a data center and it's not a publicly facing server, it's a lot easier to protect the trade secret and a lot harder to reverse engineer. It can also be difficult to detect infringement of trade secrets because if a company independently innovates and creates a similar innovation, it's very difficult to know whether they did that by stealing a trade secret or doing it on their own. And for this reason, trade secrets can be difficult to enforce and also difficult to transfer, license, and sell. In a negotiation on IP rights, it's much easier to sell a patent than a trade secret most of the time. As I mentioned, sometimes you can protect IP through copyright. And now the Copyright Act, similar to patents, says that AI cannot be an author under copyright. So without a human author, you cannot protect it. In this case listed here on the right, Naruto v. Slater, I'm sure all of you saw this in the news where a monkey got a hold of a camera and took a selfie. And it was a great picture, but it cannot be protected because there was no human involved in that process. Why? The Copyright Office simply refuses to register copyright claims if it determines that a human was not involved. And generally, the US Copyright Office says that it will not protect works that are produced by machines that operate randomly or automatically without creative input from a human. So we're going to switch gears a little bit here and talk about not the AI to innovate, but using AI to protect these innovations and maybe other innovations. One thing to note here is that this picture here on the right, I made this picture by going to ChatGPT and I said, ChatGPT, give me a picture of a robot drafting a patent application. This is what it gave me. It's a pretty good picture. I'm not sure that I can protect that with the amount of input that I gave it. So feel free to steal it and I can't do anything. Anyway, what we're going to talk about here is using AI to identify infringers, AI-assisted patent drafting, AI-assisted patent invalidation, and using AI to draft documents for courts. So let's talk about what could go wrong using AI when you are using AI to protect your innovations. Well, I'm sure we've all seen, at least the patent attorneys have all seen companies offering software that will use AI to help draft patent applications. Jack and I actually ran into a company that offered to draft patent applications for $1 US. It's a great deal. But what can happen is that AI can actually invent during the drafting process. Just as a human can invent during the drafting process, AI can do the same. So as humans, we try to focus on what is the actual innovation the inventors made, not just their implementation, but what are the extensions, the natural and obvious extensions of their innovation so that we can get our clients as good of coverage as possible. Well, AI can do the same thing. Now, what can happen is that inventive subject matter invented by AI can make it into the patent application. And during prosecution, so maybe after a few office actions, that subject matter makes its way into the claims. And maybe that is the only thing new about the claims, right? In that case, it can be questionable whether or not there was a human inventor. If it becomes known that AI invented subject matter is in the claims, there can be problems from unenforceability if this was not disclosed to the patent office, or just generally the patent not being valid for failure to have a human inventor. Similarly, in court documents, AI can invent and specifically invent things that are not true. There was a famous case in the news, it didn't have anything to do with patents, but where some attorneys used AI to draft a brief that they submitted to the court, and the AI made up cases. It just made case names that didn't exist and said that these cases supported their arguments. Well, when this was found out, obviously, the judge was very mad, sanctioned the attorneys. They were, of course, very embarrassed. And not only that, but it can also affect your client's rights, right? If you use AI in this manner and this can cause harm to your clients in the litigation, and sometimes it cannot be fixed. So in conclusion, don't lose your rights as an inventor, which means that you have to operate in order to have those rights. So this means stay informed, right? Know what you need to do to be able to protect AI. Know the limitations of using AI so that you can protect what is coming out of the AI, and document things well. I think it's also good advice to, if you are operating in many different jurisdictions, to have good legal counsel that will help guide your way in making sure that you do what you need to do in order to protect your innovations in the jurisdictions where you're going to file your patents. And also, you want good legal counsel that is going to use AI to be not only efficient for you, but also to be smart about it by not using AI in a way that could potentially harm your clients in the future. And this last line here on the slide is probably the summary of my whole presentation, and I probably could have given it in 1 minute. It's just keep humans involved in the process in order to ensure that you can protect the outcome, the output of AI that you are using. So with that, I guess I'll hand it off to Jack, and then we can maybe answer questions later.
Hello, everyone. Thank you for being here. My name is Jack, and today's topic of my talk will be about how to help your clients, specifically usually mid-sized and smaller companies that are prone to having issues related to non-practicing entities asserting their patents, especially in the U.S. I'm not sure if that's very common in other jurisdictions like Taiwan or Japan or China, but in the U.S. this is quite a big issue for many clients. But also it may not be the issue in this jurisdiction, for example, but companies that do operate or sell products in the U.S. For example, a lot of Taiwanese companies sell their products in the U.S. and they get hit with these MPE letters that they're infringing on their patents. Companies like people that make furniture, make screws, stuff like that, lighting material. So those are some of the clients that usually come to us and ask questions about what to do. So that's kind of the basis of my talk today and why I wanted to bring this up. It'll kind of lay the foundation on what steps we can take to recommend and suggest to these companies what to do when an issue like this comes around. So this is just some basic information about me. I also work in the Seattle office. I focus on patent prosecution, primarily in the cloud computing, but also a lot of AI work right now, specifically AI, neural networks, machine learning, autonomous stuff. Some of our clients also include financial services and even nuclear fusion cases. So we do a little of everything. All right, so this is the agenda to start. Just a quick introduction on what MPEs are. Sometimes they call them patent trolls, or in Taiwan, 专利蟑螂. It's pretty interesting term. But MPEs are how they send letters, how to recognize it, and how to kind of respond to those. These are some tips we could probably convey to clients. And then some recent case law and see what the MPE outlook is like in the US. And then the last part is a little mix of AI and how AI can either, potentially help these MPEs, so we should be wary, but also what we can use AI to help resolve, hopefully, MPE issues better or more efficiently. So just a quick introduction, and I'm sure most of you guys know this already, what MPEs are. They're just basically companies that go out and purchase a lot of patents on the cheap, and create these portfolios that they can assert against companies. And usually, or almost all of them, these MPEs don't make any goods or manufacture any products. And this little comic here is a funny one because both of these guys are trolls, but one troll is a patent troll, so he's more rich than the other. So what are the impacts? Well, the impacts of MPEs are very costly to companies and businesses alike throughout the world. It could indirectly or directly cost companies over $29 billion related to legal fees, to dealing with settlements, finding, doing the research when it comes to these issues with MPEs, especially as you know, it's quite expensive in the U.S. for litigation costs, right? Cost millions of dollars, but my talk here is to not be afraid of that. It is to, confidently provide information on how we can avoid that, or how your clients can avoid, going, all the way, so to speak, on, having to spend millions. That's very unlikely, and so that just wanted to provide some information on that here in the further slides, but just continuing on a little bit more on what the impacts MPEs have, usually they sue smaller or mid-sized companies because they don't have the resources to fight back. A lot of companies are startups, or they don't have a lot of legal help, so they usually assert these against these companies, hoping for a quick settlement or hoping to fight them, and they get scared. These clients or your customers get scared, and they just settle really quickly. So what impacts can that have? It could impact your R&D, or it can impact your entire company where, it goes bankrupt or ceases to exist. Like the Mycroft example up here is Mycroft was a voice assistant company, and the CEO really wanted to fight the troll, but he didn't have enough resources. So he ended up shuttering its offices and had to fire all 4 employees. And a little bit bad timing, if he had the resources or had maybe even legal help to more, or had some resources for some legal help, and maybe could have delayed some of this stuff, or delayed settlements or something, because years later the court said that those patents ended up being invalid. So a little bad timing on that part, with a mix of unfortunate he didn't have the resources to fight it. So yeah, like I was saying, a lot of attorney fees this could happen if it goes to court, and courts, however, have recently, made it a little bit less MPE friendly, so to speak, where, attorney fees in exceptional cases or exceptional reasons are being awarded to these companies and clients who fight back against these MPEs. But it's all very dependent on the location and the courts. And, just one example down here is Amazon in 2023 got awarded the attorney fees against an MPE. So that might be a reason, or that some of these MPEs are not as aggressive anymore, and that might slow down some of these MPEs in the future, but you never know. Okay, so these are just some little tips on what to do when a client of yours, the example I have in my head, is, for example, like a Taiwanese company that makes screws, right? And they make a lot of screws, and they are in the stock market here, but they also sell in the U.S. And they get hit with this MPE letter. What should they do? So that's the example I have, and that's kind of these steps I think we could provide to these type of clients information to respond or resolve these issues. The first thing, obviously, is try to work with the client, or ask the client, is this legitimate, right? And sometimes the difference between spam and these trolls can be very close. It's a fine line sometimes, but more likely than not, these MPE letters look like this. It's a vague letter, a vague claim language saying that you're infringing on our patents. It usually comes from a small or a company that you've never heard of, right? An LLC, for example, and maybe a smaller firm that represents them, and they send out these letters, mass letters for demand of money. And what are the tactics these MPEs use? Like I said, especially if your clients like mid-size or smaller, they usually attack those or send out these mass letters to them, hoping for a quick to make quick money, right? And they want to present, this lump sum. If you can give it to us right away, we'll go away. But that's something, like I'll say in the later slides, what we can do to resolve that. But and some of these MPEs are using private equity firms as backings. So they have these private equity firms think they can make money if they back these MPEs. So that's just something interesting I noticed about recent MPEs is that private equity firms are backing them too. So how do you respond? So this is something that, you could always tell your clients or recommend is, do that research. Specifically, like I said, once you go through the steps of, okay, it's a legitimate letter. It might be true that, or it might be close. This claim might be, we might be infringing on the claim or not. There's a few things your clients can do first, either, with their in-house counsel, legal counsel, or if they hire, a U.S. attorney or any attorney to help, is check, what kind of letters have been being sent in your that make similar products. For example, if the company is making screws, maybe your direct competitors have also received these letters. And these things are important because you can, as I'll say in the later slides, group together and fight back is kind of one way to do it. Group licensing, how others are kind of dealt with these issues. So kind of information from the research about these trolls is helpful, very helpful in resolving them when these issues arise. And there's a lot of databases you could use, right? There's databases now that kind of, some companies have an upload what the troll name is, what the letter is, which patents they've been asserting. Which patents they've been asserting and to which companies. So doing that research is important. And a little bit of research you could do is, like I said, the litigation database or research, the troll company and see their history, basically, of what they've been trying to assert and then which patents. Yeah, so some companies have internal policies or goals, or when they have to deal with these trolls. Some of them have, they always settle, or some of them have, oh, let's fight it. So it's good to know what these companies' internal policies are. But before they, apply any of these policies, they should definitely, ask the questions, right? Ask the questions on whether, these claims are even valid or are they even close to your customer or your client's products. And like I said, sometimes doing that research of checking other defendants or other companies in the same area could help build a better case to help you maybe find or lower the settlement costs for your company, for your customers. So these are just, I think the next few slides or things, attorneys can help with in terms of looking at the claims, looking at the patent. And because a lot of these MPEs are just asserting sending these emails or letters out, a lot of their infringement claims are frivolous or they're just like, common or they don't care, they just send it, right? So it's kind of good to enlist some help if you can, to even see if these claims are even close or even important or on point. Usually they're very weak. So here's an example of how, like, some companies, or in this case their city transit systems, grouped together to fight back. So, for example, in Seattle or King County, they settled with an MPE for about $80,000, and other cities did the same. However, they worked together to try to invalidate that MPE's patents, and they had I think a pact or a settlement where the MP would stop targeting them in the future too. The MP tried to change their company name and still assert their patents, but eventually they stopped after the judges started awarding attorney fees to the companies. So these are just kind of like tips what we can do as U.S. patent attorneys or patent attorneys in specific jurisdictions is it doesn't have to be millions of dollars, right? And it doesn't even have to be whatever the amount the MPE wants, right? For example, the MPE wants $100,000. It doesn't have to be that. I can pretty confidently say like the true settlement value is much lower, and you can kind of break them down into steps on a step-by-step basis. So companies don't have to think, oh, I have to hire an attorney and it's going to cost me millions of dollars. What we can do is step-by-step breakdown and help coach the company or the client on what to do at each stage. For example, that research stage and see if these claims are valid or not. What kind of companies they've been asserting this MPE has been asserting against, and what patents they've been doing. Do we have experience with this MPE? Sometimes our firm has, or most firms, if they've dealt with MPEs, have the experience of what the true settlement value may be. Because they know, this company will usually take a 10th or a 20th of the settlement value. So there can be strategies you can help develop throughout each stage. And each stage doesn't have to cost a lot of money. And so after you get through the research stage, maybe the next stage is just the letter, the response to the letter. And there are many times when you just respond to the letter, the MPEs go away, right? So these are just little things companies and potential clients can seek from attorneys when they're trying to resolve this issue. And also, attorneys are important because not just MPEs assert their claims, but also your direct competitors could be asserting their claims, right? So those damages could be a lot more. So you kind of have to talk with your client and inform them on the risks or if there are potentially bigger risks if it came from a direct competitor. So this is kind of the intersection of how attorneys or U.S. patent attorneys could help clients prepare to resolve these issues step by step, where potentially or more likely than not lower the settlement cost, no need to go through all that litigation stuff, and resolve these pretty quickly for way less than what the original demand was. And this is just a little thing, like I mentioned, how DWT or other U.S. attorneys can help with this. For example, settlement, they want $100,000, but the attorney has experience with this MPE, so they actually really know the true values, like $5,000 or $10,000. So that can lower the costs of your client in dealing with this MPE. And a lot of these companies may get a little flustered. They may get a little bit scared, especially if it's a foreign company and they don't have a sophisticated in-house counsel that understand U.S. patent law or patent law in general, right? So it's always, it wouldn't be, I guess, very difficult to try to prepare these companies in a way where you can kind of coach them instead of, say, hell, this definitely, or instead of they get scared and say, this is definitely a litigation issue, or this is the cost of doing business. Let's just pay and move on, which some companies do. But these are preparations can be done to prep these companies or potential clients on a step-by-step basis. So a lot of times, at least in our experience, it's kind of like a coaching step-by-step process. So that could be helpful to prepare your clients. And these are just some recent cases and outlook on how MPEs are operating and is it better or is it worse in the landscape of litigation and asserting these claims against companies. So one thing that could start deterring more MPEs is when states enact laws against them. For example, in Washington, they enacted the CPA or the Patent Troll and Prevention Act. So it became a violation of the act or the law if MPEs were asserting, these claims that are just frivolous against companies. So this is another one where what kind of impacts or these MPEs could have, and if you did go to litigation, and what companies have been doing to try to help their cause. So this case kind of I wanted to bring up just to kind of show that, if it does go to litigation, all this stuff, a lot of big companies now are, and it's very location dependent, like I said, about awarding attorney fees. So Samsung starts like donating to the jurisdiction that they find themselves in the court. So to try to get a positive feeling from the local residents. So that maybe they can get awarded attorney fees when they fight against MPEs in the future. Yeah, also, like this slide is just also dependent on the location. Like I said, if you find a good, a better location, some locations are more MPE, they don't like MPs as much maybe anymore, or a judge may not. So some of this information is just helpful for companies. And it also could, affect your settlement discussions, right? If it does go to litigation, where it is. So that's actually could affect the value of the eventual settlement value. Just as another case about ECT, Electronics Commerce Tech, or Communications at ECT against Shoppers Choice. So this is another one where they awarded attorney fees, given that they found that it was an exceptional case. It's a very high bar to meet, so it's still not as often as we'd like, but it's because of how high the exceptional reason or exceptional case is. But it is happening. This is just a slide to indicate it's not just MPEs, right? Even big companies assert their patents, like Amazon asserted their patents against other companies. So it's always good that it's not if your client or customer is receiving letters like infringement letters or demand letters, then it is good to kind of help guide them and do the research to say, here are the risks when it's against, a big company or a direct competitor that's asserting their patents, because of the damages could be much more, aside from, in contrast to an MPE. So here's just a few, bits about AI and how it could either help MPEs or it could help companies fight MPEs. One thing, that I did come across was, and Scott was mentioning this before, is using AI to invent, right? So will MPEs or will a lot more patents come out when you're using AI to invent things, because it makes it easier to invent and then perhaps easier to patent. But again, you have to go through that AI inventorship that issues that Scott was discussing earlier. But the immediate concern could be that AI, helps create a lot more patents in this world, and these MPEs could go and buy them up, or even these MPE companies could just use AI and maybe try to apply for a lot of patents there. So how can companies use AI to resolve MPEs maybe, or help companies reduce the costs maybe. Like I said, with the research stuff, AIs nowadays, I think there's AI reports on, finding prior art, helping you find prior art and generating, claim invalidation charts. So if you are hit with, companies hit with an MPE, putting those patents through an AI assisted tool to try and invalidate their claim, or generate a good response letter that shows, hey, look at all this prior art out there, right? So that I think that's potentially a good thing to perhaps look into for clients is leveraging AI and to help resolve these MPEs, especially with the finding prior art, generating reports, and so on. And also, just a quick, simple example, sometimes, MPEs is just, a cost of doing business, but, there's other ways, AI can help combat MPEs is, of course, making sure that AI inventorship is valid, but, generating more patents, and then maybe your company or potential client can license them in the future, which would then reduce the cost of doing business with these MPEs, et cetera. So yeah. So that's my presentation right there. Yep.
Hi, I'm Andy from Lee and Lee. I have a question for Scott and Jack. I'm wondering if your firm using any AI tool on your daily work, and what's your opinion on it, and any suggestions and comments. Thank you.
We are actually in the process of testing AI for patent drafting. I have done some tests myself and have found that it can be very useful and in some cases provide work product that is better than what attorneys can do, and it can do it very quickly. But I've also found dangers in using AI for patent drafting. And to give you a real life example, we had an application dealing with the backbone of a neural network. Okay, so this is software and a data path through the neural network. And the AI came up with, in the patent application, that the backbone could be some bones that are together from an animal. And fortunately, we caught this during the review process and did not file this with the patent application. But you can see that the problems that can occur when AI is drafting. Just like AI can invent cases that don't exist to rely upon in court briefs, AI can invent descriptions of the subject matter that is inaccurate or just plain false. And so what we are working on is some procedures to ensure that a human is reviewing everything that the AI produces in order to validate what it does. And hopefully the use of AI and the use of humans to validate what the AI is doing will be more effective and cost our clients less than a human doing it from start to finish. And hopefully the work product will also be better. We also have been using AI for quite a few years now for art unit prediction. So in the United States, the patent office is divided into art units, and these are just departments that deal with different technologies. Now, if you have a financial services client, their patent applications are very likely to go into an art unit where the allowance rate is very low, sometimes as low as like 5%. And in order to get a patent with an examiner in that art unit, you have to argue with the patent office many times, you have to go to appeal, and you have to narrow your claims and get very narrow in claims that are not as valuable as they could be. So what we do is we use AI before we file the patent application to predict which art unit the patent application will go into. And if it's going to go into a bad art unit, the AI tells us which words are causing it to go to that art unit. So the words might be financial or rewards or commerce, e-commerce, those type of words. And then we change the patent application, and then we run it through the AI again to see where it's going to land at the patent office. We do this over and over again until we get a prediction that is going to put it into a department that will provide us good quality patent claims without all the trouble of the bad departments. We have done this for quite a few years now, and it's been really successful and saved our clients a lot of money. It does cost extra time up front, but it's a few hours of attorney time to save many, many more hours and many, many more costs into the future.
我想提醒线上的这个听友啊，就是如果你们针对2位这个美国事务所的讲者有问题啊，也可以用中文打字，然后我们这边可以帮你翻译。好 ，But meanwhile, I have a question for Scott as well. That you mentioned that it is required to submit information disclosure statement where the invention involves AI. This is a very important information to local law firms as they help applicants to file a few patents in the States. My question is that to what extent the applicant need to disclose AI-related information to the USPTO?
That is a good question, and unfortunately, I do not have a good answer. So the patent office provided in their guidelines that inventors should disclose the use of AI. Now, it's an interesting aspect of US patent law that the duty to disclose only occurs when the information to be disclosed is material to patentability. That means it changes whether or not you will get a patent. So logically, if you were entitled to a patent in the first place, you didn't have the duty to disclose. But so you might think, well, what's the point in disclosing? But what disclosing can do is it can save you in litigation a lot of uncertainty. So in every patent case in the United States, every single one, 100% of them, the defendant says, I don't infringe your patent. Even if I did infringe your patent is not valid. And the third one is you failed to disclose information to the patent office that was material to patentability, and as a result, your patent is not enforceable. So if you disclose that information to the patent office, even if it doesn't change the outcome, help yourself in litigation by providing that information and fulfilling your duty and making it clear to the court that you disclosed the use of AI and the patent office agreed with you that the use of AI did not exclude you from having human inventors and therefore you were entitled to the patent. Now to your question about practically how do you do this, nobody knows. But I imagine it would be a brief statement in the information disclosure statement saying that AI was used as a tool by human inventors in order to come up with the invention. And for further information, please refer to applicants' representatives. I think that's what we would do, but until people start doing this and it starts appearing in the cases, we don't really know.
Thank you very much. I also have a question for Jack that at a patent troll come to their company and with a claim that is actually irrelevant to their product. So, but they only request a very small amount of money. For example, $100,000 US. and considering the expensive litigation fee in the states, they decide to settle for this useless patent. For such kind of situation, what would you suggest to respond to this kind of assertion? Thank you.
Yeah, so I think that's very common. And I think I was kind of talking about that or trying to convey that, it doesn't have to always go to litigation, and it's not always going to cost millions or hundreds of thousands of dollars. If you can enlist an attorney to help you respond to that frivolous letter, and it won't cost a lot of money to get an attorney to do that. So for example, maybe the attorney can spend, hundreds or in the low thousands of dollars to just really do that research and help you draft that letter. And more likely than not, because how frivolous this claim is, the MP in our experience will go away. So it would be advisable to, with this type of situation, to, very confidently inform the client or customer that, if you can just hire an attorney really quickly to do this one step, which is research and help you respond to that letter, it's very likely this will go away without having to settle that $100,000. Spending $1,000 or $2,000 is way less than $100,000 to give that chance. Yeah.
And I can just add from experience, we've had several cases where a very similar thing happened. And we responded to the patent troll saying, thank you for your letter. We respect intellectual property rights. And if we think that we are required to pay you a licensing fee, then we will. However, from the information you sent us, it does not appear that we do. Can you provide us more information? And every single time, we did not hear anything back. Now, that's not always going to be the case. It depends on the company, but that's why it's good to have an attorney who has experience with the trolls and knows how they're going to operate, because some trolls, if they think they have a good case for infringement, will increase the licensing fees if you respond like that. So you need to have attorneys who have experience who can guide you through that process.
Thank you. 这是再强调一下，就是线上的听众，如果你们对两位美国讲者有问题，不一定要用英文哈，用中文我们这边也可以帮你翻译。好，那我们看看到目前为止好像是没有在现场的这个来宾有没有问题？如果都没有的话，那就谢谢各位来宾，包含线上的来宾和现场的来宾，谢谢各位。